before we get going, and even before we have appearances, I wonder if we can have hard copies of the cases? Well, would be better.
Unfortunately, we don't have any hard copies for.
The respondent has 2 hard copies of Balfour and Jones in Padavagan.
Well, whatever you have.
Okay.
All right. Now we have appearances, please.
Good afternoon, Chief Justice and Justices. My name is Emily Jerome. This is my co-counsel, Joe Tracy, and we will be representing the appellant, Ms. Nina Pierce.
Good afternoon, Justices. For the respondents, Peter Dawson and my co-counsel, Daniel Finn.
Thank you. Proceed.
May I proceed?
Yes. Proceed, please.
Before I begin, would it please the court to hear statement of the facts?
No.
This case is about protecting the reasonable reliance of the expectations of parties who enter into contracts. The appellant respectfully asks the court to reverse the lower court's decision which held that the sticky note is not an enforceable contract as it was formed in the familial context and does not contain the requisite elements of offer, acceptance, and consideration. I will first address the issue which relates to the familial context of the agreement and the intentions of the parties to be bound. My co-counsel will then address the second issue, which relates to offer, acceptance, and consideration. The law will not proclaim the existence of a contract merely because of the presence of mutual promises. Rather, enforceability is predicated on a finding that both parties intended their agreement to carry legal weight. Without this intention, agreements made in the everyday social lives could potentially create legally enforceable obligations to which we could be sued if we do not comply. To offer to take a friend out for coffee is not to invite litigation. Nevertheless, some domestic agreements are in fact made with the intention to be bound. And that is the case with Pierce and Denson. And where the interests at stake warrant it, and the conduct of the parties exhibit it, the court should be prepared to protect the reasonable expectations of the parties. The foregoing analysis will proceed by first demonstrating that although the presumption against an intention to be bound by legal relations is raised due to the domestic context of the agreement, the language of the parties and the conduct of the parties, along with the circumstances in which these behaviors are exhibited, indicate that there is sufficient evidence to rebut this presumption. And this is for 3 primary but interrelated reasons. Firstly, the certainty and clarity of the note. Secondly, the explicit reference to repayment.
Well, the note's not very clear. The note says, I'll try to repay.
I can address that issue now if you'd like.
Sure.
So yes, let me see what I can do is used by Denson in the note, and this statement mirrors that made in Dugas and Dugas, whereby the son stated that he would try to pay what he owed with regards to his to repayment of room and board to his father. And the court in Dugas was willing to overlook this uncertainty, and in doing so distinguished between 2 situations. And this argument can be found in paragraph 26 of the appellant's.
But the problem I have with that is that in this case, so you said the circumstances are also relevant, and in this case, what the appellant is saying is that the arrangement was for Denson to give her a car, really. And she makes some payments, it would just happen with the cash flow, but really he was going to give her the car because she's making payments to him, and then at the end he pays it all back. So she really is getting the car for nothing. So it seems to me that you're selling a car, and I'm just looking at a quote from Jones here about the rationale for this familial context. Whether this was simply a family arrangement in which one member of the family relies on a promise given by another person and trusts that person to carry out the promise. So I can see on the one hand, she's thinking, well, I'm buying a car, and hopefully he'll end up giving it to me, but worst case, I got a car, and it's worth $5,000, I'm paying $5,000, and so she's just relying on this promise and trusting him to carry it out without any intent that it'll be legally enforceable, because worst case, even if it's not, she's still getting a car for fair market value.
Thank you for your question, Justice. As I understand your question, you're asking, sorry, could you repeat your question?
Well, I guess it's not a question so much as what is it about the circumstances of this case that makes us think that this should be legally enforceable? And it's specifically to me, the salient circumstance is she's really asking the court to enforce his promise to give her a car. And surely, if he had just said, I promise in 2 years to give you a car, that wouldn't be enforceable in a familial context, would it?
No, Justice.
So this is really not very different, because the net effect is she's asking us to enforce the promise to give her the car. She's transferred money. You want us to transfer it all back.
Thank you for your question, Justice. I think the issue in terms of the statement, let me see what I can do, is in reference to the fact that she's asking for enforceability of the promise to try to make repayment. So, let me see what I can do about repaying you. There was never any attempt by Denson to make any sort of repayment for the car.
Is a promise to try enforceable?
I'm unsure, Justice.
And I didn't know there was no. Okay, proceed.
I will begin with my first argument, which you can be found on paragraph 20 of the appellant's factum. And the appellant's factum references the case of Dugas and Dugas multiple times, and this is because of the striking similarities between the facts of both cases. So would it please the court to hear a brief statement of the facts of that case?
Sure.
So Mr. Louis Dugas sought to recover $3,500 for room and board that he supplied to his recently deceased son. His son was in debt and had recently lost his job, so there was a verbal arrangement established between the father and son, wherein it was agreed that Mr. Dugas' son would pay his father $25 per week for room and board. However, given his dire financial situation, the son was only ever able to provide $100 of the $3,800 owing, but made a verbal promise to repay the balance when he could in the future. And the court held that the circumstances of Mr. Dugas and his son, along with the language and conduct, was enough to rebut the general presumption against an intention to be bound by legal relations. And in making this finding, the importance of specific payment schedules and written recordings of dues was referenced as a factor that would typically accompany a formally legally binding contract. And this element was unequivocally made out between Denson and Pierce. The arrangement for repayment was reduced to writing, written with precision, and evidenced with a signature.
In Dugas, you're saying?
No, sorry, in the case between Denson and Pierce.
I thought we were talking about Dugas. Lost there.
A little bit.
I'm sorry, I will finish.
Last I remember, we were talking about the facts in Dugas.
And the court in Dugas held that the circumstances of Ms. Dugas and his son,
Right.
along with the parties' language and conduct, was enough to rebut the general presumption against an intention to be bound by legal relations.
Can I ask,
Okay, no, go ahead.
sorry, have there been any recent case law that has cited or referenced Dugas? The reason I ask is I'm looking at your schedule of authorities here, and the majority of your case law is from the 60s, 70s, a couple from even earlier than that. I think your most recent one is from 1996. And so I'm just wondering, do you have any recent case law that's upholding or that's referencing the arguments that you're making?
There's been one recent case, and it was held at the Nova Scotia Small Claims Court, and it's not referenced, it was not referenced in the factum, but I can provide a copy of it.
Please. And so for the benefit of my colleagues, can
Yeah.
you give a brief summary as to
Absolutely.
this case?
So this was a case, like I said, heard in the Nova Scotia Small Claims Court in 2009, and it was between a boyfriend and a girlfriend who had been cohabiting for 3 years, and there was a claim and a counterclaim, and the claim was the girlfriend stated that she had provided a loan to the boyfriend of $4,000, and he made a counterclaim stating that he wanted to seek remuneration for money that he had paid out throughout the course of the relationship. And the initial claim of $4,000 was upheld by the court, but the counterclaim was not found to be legally enforceable. And in doing so, the court held in paragraph 7 of that decision that the defendant is not entitled to recover anything for what he believes the claimant ought to have contributed during the relationship. He did not demand it at the time, and he may not do so now. So this speaks to the fact that the parties must treat a contract as a contract when it occurs and not go back retrospectively and decide, well, I paid out a certain amount of money, I'm going to go back and try to enforce that obligation.
I have a question. Maybe going back to the trial more than the case you were just talking about, but what weight, if any, do we put on the fact that both your client and the respondent are lawyers? So presumably they know about the familiar context exception, so do we put any weight on the fact that they have more knowledge of the law than the average Joes in these cases that you're referencing?
Thank you for your question, Justice. I don't think it's appropriate to impart some higher wisdom on behalf of the appellant and the respondent, especially given the situation with Mr. Denson, who was fired from his job because he wasn't familiar with basic tenets of contract law. And in doing so, I don't know that there's necessarily some sort of baseline that you can impart on everyone. That answers the question.
I guess the basis of my question is, your client, if she really intended, and knew of this familiar exception, would she not have included it in the actual formal contract that they drafted? Since you're saying that they talked about it at the time it was drafted, etc.
And I think you make a very good point in terms of why wouldn't they just add in these terms if they were already in the process of establishing the financing agreement. And I don't know that, given the objective nature of the test and having to interpret the conduct and language of the parties from an objectively reasonable standpoint, it's appropriate for me to look at the subjective reasons as to why something did or didn't happen in the situation. It could be something as simple as a procedural issue as to why that didn't occur.
I would have thought we have to look at this objectively, and objectively, seeing as they were actually drawing up a formal contract, anything that didn't go in the formal contract, not intended to be part of the formal contract.
Right. Building off of that, and perhaps maybe it's not as relevant as I think, and I'm going to ask both parties if they put any thought into the parole evidence rule, whereas once the contract has been put down in writing, generally any previous oral agreements or negotiations aren't to be considered. So when putting down the financing agreement into writing, it would have made sense to put in all the agreements into this one document. And the fact that it was overlooked, I think, is something that you need to address.
Thank you for your question, Justice. Issues with regards to the offer, acceptance, and consideration will be addressed by my co-counsel, but with regards to that issue, I think in writing out the sticky note in and of itself acts as that written component and will, as my co-counsel will show, act as a collateral contract to the financing agreement.
But on its base, it just looks like a promise to try. And particularly because it's just a sticky note. So, I mean, the story more or less that your friends are telling is that this was a deal for the sale of a car. And Mr. Denson agreed to sell the car to Ms. Pierce. And that was their deal. And he said, oh, and by the way, hopefully, like, I can actually give it to you. And the hopefully I can give it to you is just a promise to try and give it to you, but it's not intended to be legally enforceable. It's just, they're cohabiting and getting along, and he's going to try and give it to her. But really, what they're doing is she's buying the car from him, and that's the legally enforceable part. So that's consistent with this sticky note, because the envelope was all in the envelope. It's kind of the last thought, and oh, by the way, I haven't forgotten that I'm going to, I want to give this thing to you. But the legal part, that's why that wasn't in the formal document, is because it wasn't intended to be enforceable. It was just reminding of this promise, but the mere fact that he's made a promise isn't in itself enforceable, at least in this familial context, as I understand it.
Thank you for your question, Justice. I think you brought up a good point with regards to the fact that it was included alongside the the formal contractual document, and the fact that he laid out these essential terms, he wrote it out, he signed it, and then he included it alongside the document, but he did all of this in the presence of Pierce. If it was merely something he wanted to remind himself of in the future, he could have made a mental note of it, or sent himself a text, or written it on his personal calendar to remind himself, but instead he made the conscious decision to go further and to do this in front of her, so she knew that there had been this intention.
Well, she knew that he was making a promise, but the question is whether they both believed he was making a legally binding promise. But anyway, we may proceed with this.
Okay, I will proceed to my second argument, which begins at paragraph 29 of the appellant's factum. And any objective analysis of the words and conduct of Pierce must be done in tandem with the circumstances of the parties at the time of the contract formation. So objectively viewed, the surrounding circumstantial factors of the parties entered into the sticky note agreement with the intention that their actions carry legal weight. And in Dugas, in paragraph 14 of that decision, the court considered contextual evidence relating to the father's poor socioeconomic status to indicate that he would not freely give away such large sums of money without expectation of repayment. And similarly, Pierce's income was only $35,000, and she also had six-figure student debt that she was in the process of repaying.
Right, but there's a little bit of a difference here where she's not giving away and receiving nothing. She's essentially buying a car.
Thank you for your question, Justice. She does receive the car, but on the facts, she stated that she didn't need a car. She was fine getting around the city without it. She was motivated to enter into the agreement for two reasons, one being the repayment of that she would eventually get, and the second being able to help her boyfriend at the time with his cash flows as he purchased a new vehicle. And on the note of repayment, she, at the end of those 4 years, it would amount to $4,800. And this amount is not trivial nor insignificant by any terms, but Pierce had so little that to give away such large sums of money, although it might appear generous or pro-social, economically, she simply couldn't afford to do so without the opportunity to exercise legal recourse should the situation be breached at a later date. An individual in this situation, in such a low socioeconomic status and high debt-to-income ratio, would secure a firm agreement on repayment for the vehicle prior to undertaking an agreement with such high risk. And I would like to quickly go over the court's, provide a brief conclusion on the appellant's position.
I
Do
think
you have
we
any
have
time
time.
left? Yeah, go ahead.
The agreements formed in the familial context raise the general presumption against an intention to be bound. Nevertheless, some familial and domestic arrangements are made with the intention to be legally enforceable. This is the case with Pierce and Denson. The parties express themselves outwardly in a manner that indicates both an intention to be bound and reasonably certain mutually agreed upon terms. Therefore, the appellant respectfully requests that the court protect and uphold these reasonable expectations by reversing the holding of the courts below. Thank you.
The second grounds of appeal is that the trial judge, the trial judge erred in not finding valid offer, acceptance, and consideration. The appellant submits that there was valid offer, acceptance, and consideration in the sticky note contract. The offer was valid and enforceable, and will be argued on 4 key points, and that is the direct communication from the respondent to the appellant, the objective intention of the respondent and the intention to be binding, oral agreements and the enforceability of those, and then this has to be looked at in totality with the rest of the offer, in that the sticky note was included and signed and put in the envelope with the rest of the legally binding documents. And in the alternative, that the courts find that the sticky note, in the words that the respondent used, were too ambiguous to be enforced, that the contra profferendum principle should be applied. With offers, as we know from Blair and Western Mutual Benefits Association, is that offers need to be directly communicated and be capable of being accepted. In the facts that in this case, it is clear that the respondent directly communicated, both verbally and in writing, with the appellant, and that in any breach of contracts case, we have to ascertain the intention of the parties. In Fire Insurance Society and W.M. Price from the Australian High Courts, the judge stated, intention is to be ascertained from what the parties said or did. So what did the respondent say? If you turn your attention to paragraph 3 in the facts, it is established there that the respondent promised to pay the appellant back. What did the respondent do? Well, the respondent writes...
Well, actually what it says is that Pierce testified that. I mean, it says that Pierce testified that at the end of the 4-year period, Denison promised to repay her. Doesn't say that, it's not found as a fact, or is it?
Well, I guess in the sequence of facts that would be provided in the brief, it does just say that.
Yeah, well, it is, thank you for your question, Justice. It is included in the statement of facts and is found as a fact by the trial judge. It was not contested by the appellant, by the respondent. So the respondent writes a sticky note and includes it in the contract offer, and it says, like we talked about, remind me to see what I can do about writing a check for the total cost of the Civic at the last month of the 4-year period.
But now that on its face is clearly not a promise to repay.
Right. So thank you for your question, Justice. That sticky note in tandem with the oral promise indicates an intention to be bound, and by using a specific date and a specific amount is further evidence of the intention to be legally binding. The jurisprudence on oral agreements prior to contract formulation, I'm referencing the case of Turner and Fisher from the BC Court of Appeal, which is a 1996 case. And in that case, the judges said that, or the justice said Oral agreements can be enforced as long as they do not contradict the written contract. The appellant submits that this sticky note and the oral agreement that comes with this does not contradict the financing agreement as a whole. And also, that this sticky note should be looked at in totality with the rest of the offer, in that it was included and it was signed, and it was included with the rest of the contractually binding documents enforceable.
So you don't think it contradicts the written agreement at all? I mean, basically, it's kind of invalidating the written agreement, saying that, yes, you pay us for 4 years, but you're gonna get all your money back. I think that's a pretty big aspect of the agreement to leave out.
Thank you for your question, Justice. So the agreement was to make a monthly payment of $100 for 4 years. So that was the appellant's detriment in that, and the promise of repayment is separate from that, in that for 4 years she had to have the detriment of having her money basically locked up. And in the facts from the trial judge, it stated that she was fine without the car, and the respondent's oral assurance induced the appellant into entering into this contract in the first place. And may I proceed? Yeah. So if in the alternative the courts find that the respondent's terms of "let me see what I can do" to be too ambiguous, then the contra profferendum principle should be invoked. The contra profferendum principle is, it's Latin for "against the draftsman," and as detailed in the textbook Cheshire and 5-Foot, Law of Contracts, 9th edition, it details the situation that it can arise and be used. If there is any doubt to the meaning and scope of the excluding or limiting term, ambiguity will be resolved against the party who has inserted it and is now relying of it, as he seeks to protect himself against liability to which he would otherwise be subject. It is for him to prove that the words clearly and aptly describe the contingency that has in fact arisen. So following the contra profferendum principle, the courts should see that the ambiguity to be resolved in the favor of the appellant.
Maybe it's not ambiguous, it's just he's promising to try to pay her back.
Right.
And that's all there is. It's not actually a promise to pay back. It's not ambiguous.
The ambiguity comes from the combination of the oral assurance and the written document, the mismatch of those. May I proceed to acceptance? Yes. So the jurisprudence in Canada is that acceptance is valid by conduct, and in the situation at hand, the appellant has done a valid acceptance by conduct by making the payment. So the test for acceptance by conduct comes from St. John Tugboat Co. and Irving Refinery, and that basically lays out what a reasonable person would understand to be accepting a contract can be enforced by the courts as being valid and enforceable as acceptance, valid acceptance. So a reasonable person would ascertain that the appellant's action of making a payment was clearly accepting of the contract.
Well, and I think it's, oh, go ahead.
I was just gonna say, isn't that just conduct that she accepted the financing agreement without the sticky note? She
Right.
would do the exact same thing.
So, my final point is on consideration, and I'm going to be talking in the collateral contract context that this arose in. And essentially, the one act of acceptance accepted both contracts, in that it accepted the financing agreement and the sticky note contract.
I understand your argument. My problem is that she would do the same thing whether she was accepting both or just the formal one. So how can we say that it's both
Right.
and not just one?
So this is a circumstance where there's one oral assurance, which she relied on, and one financial agreement, which she has signed to. So the consideration in this circumstance for entering into the first agreement, which she didn't really want to do, but she was only pressured into by the respondent, is that the consideration for contract A, the financing agreement, was her detriment of entering into contract B. That's it. So,
What's contract B?
excuse me, so I'll rephrase that. The consideration for contract B, so let's call it the sticky note, is the detriment of entering into contract A,
So
which
we
is
are
the
saying
financing
that there's
agreement.
two contracts here then.
Exactly.
So B is no longer collateral to, or no longer considered to be part of A. B is its own separate contract now, the sticky note.
Correct. So there's been quite a few times where this has been applied in the courts and held to be a valid situation. So in Harish and Bank of Montreal, there was a financial agreement between this man and the bank, and he was given an oral assurance by the branch manager that of certain limiting terms, that he would only be limited to a certain amount. But the form that he signed did not agree with what he was told. So later, the courts stated that the evidence of the conversation between him and the bank was admissible, and then they honored the oral assurance, and they found that the consideration was found in the bargain detriment of him entering into the financial agreement.
Isn't that different though? Your client knew she was signing a financial agreement to pay, was it $100 or $200 a month for the car? It's not, she didn't not know what that was. Like the man that you referenced talking to the bank.
Could you rephrase your question, Justice?
I think that there's a clear distinction from the case that you're referencing where you say that the bank told the man something different than he actually signed, where here your client completely understands what she's signing, that it's a financial agreement, and is aware that this one clause is in it and is attached to it by sticky note. So I'm just, can you draw the line for me of how we're connecting these two cases, is what I'm asking.
Yep. Thank you for your question, Justice. The connection is that there was an oral assurance that induced someone to sign a contract, and then later the financial agreement disagrees with what the oral assurance is, and in that case, the justices agreed that the oral assurance is admissible and that they honored that oral assurance over the written document. There's another case that is more analogous to this, and that's Evan and Andrea Mazzaro. And in that situation, it was a shipping contract where the shipping company gave an oral assurance that that the shipping container will be below deck, and the person that was having their items shipped signed a form from them that said that the shipping company could put the container ship wherever they wanted, below deck or above deck. And the shipping company ended up deciding to put the shipping container above deck against the oral assurance. And then later, the shipping container actually fell off, and the question was, is the oral assurance valid in that it was contradicted by the written agreement that the person signed? So in this case...
And what was the result in that?
Yes, in this case, the judge held that there was a breach in contract and that the shipping company couldn't rely on the written agreement, and that the promise to carry goods below deck was enforceable collateral contract to the shipping contract. So the express term,
And what level of court was that?
that was from the English Court of Appeal,
Was
1976.
this case cited in your brief?
No,
Do you have a copy of the case?
I don't, sorry.
What difference does it make whether this is a collateral contract or an independent contract?
The collateral contract answers the question of consideration, which changes the entire circumstance from being one of a gratuitous promise to an enforceable contract.
So this is a collateral contract?
Correct.
Didn't you just say it's an
Yeah.
independent contract? I'm sure you said that
I
five
have
minutes
that
ago.
note written down, it's its own separate contract now.
Not even, is it? Is there anything in here about collateral contracts in your brief?
Sorry?
Does your brief talk about collateral contracts? You've just been talking about it.
Yes, in paragraph 42 from the appellant's background.
I see.
May I proceed?
Do you maybe just want to clarify then, what the position is? Is it a collateral contract or is it a separate contract?
It is a collateral contract.
You can proceed.
So, in conclusion, each required element of a valid contract is made out. The offer was directly communicated and intended to be binding. The respondent objectively intended for that to be binding, and that the oral agreement is enforceable, and the sticky note needs to be looked at in totality with the rest of the contract offer. This isn't a sticky note that was on a fridge or left in a library. This was included in an envelope and signed by the respondent. And the offer was validly accepted by the conduct of Pierce and the appellant here. And the consideration is found in that this circumstance happened in a collateral contract, and that the bargain detriment for the appellant is found in the action of entering into the financing agreement.
So let me ask you one question. Suppose there was no evidence of a prior oral agreement. Would it still be, would the sticky note on its own be sufficient for us to find a binding contract?
If I were to speculate, I would
Well,
say,
make a submission as a matter of law,
Right.
whatever, yes.
I would submit that no, the sticky note alone likely does not make out a valid offer, acceptance, and consideration,
And that's
But- because the ambiguity and in the circumstances of let me see what I can do, the appellant's position is that the oral promise should override the sticky note insofar that it says let me see what I can do. Which was, yeah,
I understand that, I was just trying to understand where the crux of it is.
So, may I proceed to the order sought? The appellant respectfully submits that the appeal should be allowed and damages awarded in the amount of $4,800 for the breach of contract, and in addition, costs should also be awarded to the appellant.
Thank you.
Mr. Dawson, correct?
Yes.
Proceed.
For the respondent, I'll be arguing issue 1, the familial context and whether there was legal intentions involved. My co-counsel, again, Daniel Finn, will be arguing whether there was, that there was no valid offer, acceptance, or consideration. First, I'll direct the court's attention to the fact that the agreement was made in a familial context, and then I'll move on to indicate that that it cannot be inferred that legal intentions were intended by Mr. Denson. So, Balfour states that an agreement made in a social or familial setting has a rebuttable assumption of legal consequences not being intended. This remains rebuttable, and you can infer intentions based on surrounding factors. Respondent submits that this case falls into this rebuttable presumption. The appellant and respondent were a couple for 3 years at the time of the arrangement. They remained a couple for another 4 years after it. Beyond that, Balfour goes beyond just husband and wife, or blood relatives, or as evidence of this, respondent cites Ang v. Evans, an Alberta Court of Queen's Bench case, where an agreement between friends for the sharing of Calgary Flames hockey tickets was found to not have legal intentions because it was made in a social setting.
So there wasn't a written agreement in that case?
There was, it was just an oral
Unlike
agreement.
this case?
Yes. Yes, the respondent submits that if friends are afforded the ability to have the Balfour presumption, then so should a serious couple.
I'm not sure the Balfour presumption is really good for the parties.
Pardon?
Well, I'm not sure it's a, why is this whole thing a good idea? I mean, this is a when is it?
The 1991?
1919 English decision when, you know, relations between husband and wife, I'm sure, were quite different from what they are today. And why should we pay any attention to this?
Yes, in terms of a policy question such as that, first and foremost, Balfour has never been overruled. It has been applied to multiple cases over the past century. Second, relationships have evolved, but for needing more protection of the Balfour principle. Now we have common law spouse protections. Relationships have evolved over time to be more inclusive of the Balfour principle.
Do you have any recent case law that cites or references the Balfour principle?
The most recent would be, I believe, the most recent one that we the respondents have.
Court of Queen's Bench, I mean.
And that was which one were you referring to?
Ang and Evans.
That's the 1991 one?
Yes.
That's the most recent case?
Yes, there are more recent cases.
And I mean, we don't know very much about it, but on the face of it, if I say to you, we're friends, and I say, buy me Flames tickets and I'll pay you back, and it's $1,000, and buy me the ticket, well, you know, that's what the facts are, I'd be inclined to hold it wrongly decided.
Thank you, Justice. I take your point. There was a more comprehensive agreement made, and that it was spread out through 2 years, and that they did share tickets. But yes, I understand your point that it was very gratuitous in that situation. But the point in referencing Ang and Evans is that friends, co-workers in that case.
Well, but my point is I'm just not at all convinced it was correctly decided, so it's not really, it's not very good, it's not very strong authority. I mean, it's the Alberta Court of Queen's Bench, and from the little I've heard, I'm not inclined to think it was rightly decided, so do you have any other authority?
Jones and Padavatten is cited as authority. I know it's a 1969 case.
Where do you cite that? What paragraph?
Paragraph 10 is when it's first cited. May I proceed?
And what did he decide it was or was not legally binding?
Oh, pardon me, Justice. He decided that it was a relationship between a mother and daughter. would you prefer I give a brief facts of what occurred there?
Did the court actually decide it was legally binding?
No, no.
No, okay, then yes.
Yes,
Give us some
it
facts.
supports the respondent's position.
Give it, sure, I'd like to hear some facts.
Okay, so mother and daughter, there was an agreement. The mother promised to pay $200. The daughter lived in the United States. She promised to pay her $200 a month if she moved to Britain to study for the bar, to become a lawyer. She ended up paying her $42 because there was some confusion about the currency, which currency was being talked about. So, and the contract was varied to, that $40 turned into housing. Instead of $42, she had a free place to live in England. And eventually the mother evicted her, and the daughter took it to the English court, citing that they had a contract between that oral agreement. And the original court actually sided with her, but the Court of Appeal said that it was in a familial setting and that there were no legal intentions.
I think I'm just a bit confused about your basic position. Are you saying this is not a family context, or it is, but it is rebutted?
No, it is, thank you, Justice, it is in the family context, and it is not rebutted.
Okay, it is and it is not rebutted.
Right.
I don't know, I'm having a lot of trouble with Balfour, where the court seems to be saying the husband agreed to send the wife £30 a month, and then he changed his mind and they let him off the hook. It's just, it's not. This Balfour principle seems to be saying that people can make, as long as you're within a family, you can lie to the other person and the law will let you get away with it. It just doesn't seem to be a very sound principle.
I understand your concerns, Chief Justice. The reasoning and the policy reasoning behind it is because there's so many promises made between couples or father and son that are simply gratuitous and not meant for courts to get involved and to enforce. That is what the Balfour principle is aiming to protect against.
Right, but wasn't it written somewhere that your client had admitted that if she had stopped paying, he would have sued her?
The respondent submitted that it would have been okay for him to do that, yes, per the written financial agreement. The respondent submits the written financial agreement was clearly binding.
But I mean, that's an agreement between, so why is that one rebutted and the other one isn't? I mean, you're
Because-
just picking and choosing here.
Yes, Chief Justice, because of the surrounding factors and the fact that the written financial agreement was so formal and clear, it had every...
But oral agreements are binding, oral contracts.
Yes, but the sticky note in question, the respondent submitted is not.
So you're not distinguishing this on the nature of the familial relationship, which is the same, and you're not distinguishing it on the surrounding circumstances, which are the same. You're just distinguishing it only on the basis of the degree of formality of the contract.
The respondent's submission is that this is in the familiar setting.
So if there had been a promise, if instead of writing this all out, the sale of the Civic, or what
Yes.
you're arguing is a sale, so your argument is he agreed to sell her the Civic, she agreed to buy it. And he said, well, maybe I'll pay it back, and that one's not enforceable, and the first one is. So if the agreement to sell had been, he transfers the Civic into her name, and she says, yeah, I'll pay $100 a month for 4 years, XXOO, that would not be enforceable.
Thank you for your question, Chief Justice. That hypothetical is difficult because it includes the informal language of the XOXO.
Well, that's my point.
Right, in the case of Barlow, the fact that there was a sticky note separate and there was also informality in the sticky note that wasn't present in
So
the...
your submission, though, is in my hypothetical where it's purely a sale. She promises to pay $100 a month, he transfers title to her, she stops paying after 6 months, he sues, he says, give me the car back or start paying me.
Yes.
But the only evidence of the contract is a sticky note. You are saying that your submission is that is enforceable or is not enforceable?
No, the response is that he could not sue based on the sticky note. The appellant could sue if he revoked the car for no reason. And the respondent could sue if she stopped paying. But the response submission is that the appellant should not be able to sue for the gratuitous promise added on after, attached to the written financial agreement.
Well, I understand that, but I'm still trying to, I understand that's your submission, but As I said, the familial relationship is the same, the surrounding circumstances are the same. The only distinction between this contract to buy the car, which you say is enforceable, and the contract to pay back the money at the end, which you say isn't, is the degree. One is written, typed up, and the other's on a sticky note. Is that your submission?
No, that is not the respondent's submission. The difference is the wording in the sticky notes, like we talked about, which is a promise to try, which is not.
But you've agreed that there was a promise, and this promise to try business is beside the point because you've agreed to the fact that a promise was made. And this note is just evidence of that promise. It's not the promise itself.
Yes, Chief Justice. Respondent submits that, as Justice Lico indicated earlier, the written agreement should be paramount to the parole evidence of any oral agreement.
Well, what do you say about the contra profferentum rule? I mean, to me, I think your friends have a pretty good argument that what's going on here is it was found as a fact that he made a promise to pay. He's memorializing this and trying to weasel out of it. But it was found as a fact, he made a promise to pay, and you've agreed to that fact. And so the fact that he's, using weasel words when he actually writes it down, we shouldn't pay attention to that.
Thank you for your question, Chief Justice. My co-counsel will talk more about the contra profferentum rule, but I will just state that, as you indicated earlier, that the sticky note's actually not that ambiguous in terms of it is a promise to try. So
Well, the sticky note's ambiguous, but the problem is the facts were found that there was a promise that was not ambiguous, and you agreed to that fact. And so the fact that the sticky note might be a little ambiguous, well, it's just evidence of the earlier promise.
Can I break through the wall here for a minute? The respondents did ask a couple of days ago whether to amend things to say that it was merely testified to as opposed to a finding of fact, and they were advised not to do that.
But now they're stuck. I mean, you're stuck, you're still stuck, right? I understand you raised it, but you agreed to that fact.
May I proceed with, I'll talk a little bit more about the surrounding circumstances in this case. 3 factors, and most importantly, the context of the sticky note, it being separated from the written financial agreement, the wording of the sticky note, the XOXO for informality, and the like we talked about, let me see what I can do for the vagueness. And then the legal knowledge as well, as of both the appellant and the respondent. So the wording of the sticky note conveys a completely different meaning than that which was testified by the appellant at the trial.
Can I just ask where we are?
We're in paragraph 13. The test that's laid out in Jones and Padavatten is an objective test that a reasonable person should, a reasonable bystander, what would they think of the sticky note just happening by if they knew of surrounding factors. Now, the respondent submits that a reasonable person would clearly observe that the sticky note does not promise to repay, but rather promises to try to repay. As the Chief Justice indicated earlier, the respondent would submit that a promise to try to repay is not enforceable. And alternatively, if it were to be enforceable, there's no evidence that he didn't try to repay.
And where is your authority for the proposition that a promise to try to repay is not enforceable?
There is, I don't have one at this time. But again, alternatively, if that is not the case, there's no evidence that he didn't try. He lost his job, perhaps he...
Well, I don't know. I think, however, in October 2017, Denson refused to repay. I mean, that seems to me like that's refusal. It's not that he tried to write checks and they bounced because he didn't have any money. In fact, it says that he still has a sizable balance. So he has a sizable balance. It's found as a fact, therefore, that he has the ability to repay. He refused to repay. But I would say that's quite clear that he didn't try.
Your justices may determine that he didn't try. Respondent would still submit that there is no clear evidence that he didn't try. Him being laid off at the time, just because he refused to pay, there were clearly financial circumstances that reinforced him doing so. Even if the respondent in the sticky note promised to repay the $4,800 to the appellant, it would still be a promise made in the familial setting, which is not actionable as indicated in Jones, per the quote in paragraph 14, where this was a promise by Denson in the oral agreement, Mr. Denson, that the appellant hoped would become true, a gratuitous promise that she hoped he would fulfill, but it was made between a couple, and Jones and Padavatten says that those are not actionable. You cannot bring action based on that.
Well, it doesn't say that. It says there's a presumption. It's clear it can be actionable in certain circumstances. And in these circumstances, the evidence was to the effect that she would not have agreed to the arrangement but for his promise to repay. And isn't that enough to take it out? I mean, you've acknowledged that the sale agreement itself is legally enforceable, and it looks, as I read the facts, this was part of that whole consideration for that sale agreement. She would not have entered into the legally enforceable sale agreement but for the fact that he promised to repay at the end.
Yes, Chief Justice, that is what she testifies at trial. There is no way to know for sure. The question that Chief Justice
Well, there is
raised.
a way to know for sure, which is the trial judge makes finding of fact, and then we take it as a fact. I'm just trying to see what the facts are. I do say that, as far as I can see, the agreed facts don't make any mention of the notion that, oh yes, but it's a fairly clear finding of fact in the trial decision. The promise of repayment motivated Pierce to enter into the arrangement. That looks to me like a finding of fact by the trial judge.
Yes.
It doesn't say she testified that, she just says that.
Right after he indicates twice that she testified. I take your point. I don't believe that's in the statement of facts as presented.
No, but it's a statement by the trial judge on the matter of fact.
Okay. I'm going to move to distinguishing the leading case that the appellants have cited, Dugas and Dugas. Quickly, I'll just, my opposing counsel has already given you brief facts in Dugas. So I'll just indicate that the four factors of why the justice overturned the decision therein. The four main factors were that there was partial repayments of the agreement. The respondent, there was corroborated discussions about paying back the money. Only the appellant's testimony Secondly, the respondent Secondly, there was a clear intention, conveyed intention by the son in Dugas to pay back his father, which the respondent was not present herein. That it wasn't a clear intention. It was quite vague. It was a promise to try. There was also no repayment at all, as there